This morning on the Ag Issues program, pleasure as always to bring onto the program Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law. We haven't done this for a while. We're actually both in studio this morning. Roger, good morning. How are you?
Good morning, Greg. Good to be with you.
Well, appreciate you coming on as always. First thing we want to talk about, of course, property rights, private property rights in this case. And I don't know how many times we have talked about the ag-gag law up in the state of Iowa, but there was some recent news on some of the specific parts of the ag-gag law.
Yeah, that's right. And this Iowa law has been in and out of the courts for quite some time, and it's been revised given what the courts have said over the years. And a number of states have these. Of course, this has been an issue in Kansas. Kansas has one of the earliest statutes, and it was ruled unconstitutional and on free speech grounds. And other states have struggled with this, and parts of the Idaho law have been upheld, for example, and other states have had problems with theirs. But we are back in Iowa, and the Iowa ag-gag law, as I said, we've been dealing with this for 10 or 15 years in and out of the courts. But recently, the most current version of the law up there that bans a trespasser's use of a camera or recording in a confinement livestock facility was upheld as constitutional because the court said that the law directly advanced the state's substantial interests in protecting property rights and privacy while leaving the groups that were challenging the law ample opportunity to get their message out in a lawful manner. In other words, you can't be trespassing at the time you want to take videos and take pictures and post them to hurt the business. They said, well, you have legal ways to do that, but you can't do that as a trespasser. And so the Iowa law has been upheld. And Greg, I think that's going to send a signal to other states in terms of this is how you do it and pass constitutional muster.
Yeah. Because not easy, and especially how many times that this law has been, as you mentioned, in and out of the courts as well. And like we were talking beforehand, this was really one of the last pieces of that law that hadn't been taken to court or talked about in court in this case, too.
Right. The Iowa statute had gotten all the way to the Eighth Circuit Court of Appeals, and the Eighth Circuit said there's one piece of the law we want the lower court to rule on first. And so they kicked that part of the case back to the lower court. Now, and so what this case was the lower court's ruling was in response to a question that was sent to it from the Eighth Circuit, which had previously held that the portion of the law that made it a crime to place a camera inside a confinement livestock facility was okay, but they held off ruling. See, what happens here is that the appellate court is saying, well, we have a state law question. We need the lower court to determine the state law issue here. And so they asked the lower court to rule on the question of whether Iowa could also bar the use, not just the placement of a camera, but the use of a camera or a recording device while a person was trespassing inside a confinement livestock facility. And the lower court said most recently, just a few days ago, yes, Iowa could do that. The law is constitutional. And that's where I think we're going to have implications for other states that are trying to protect confinement livestock facilities.
And especially how many states really since then, since the inception of the law in Iowa, have really come to the forefront as far as wanting to install the same type of law.
Yeah, it's a big deal in the livestock states, what I would call the livestock states, where livestock production is predominant, plus poultry, because poultry is raised in confinement situations, and there are these groups out there that are intent to do harm to these types of facilities. And so this is a reaction, a legislative reaction. It's a pushback to that type of conduct. And it's interesting how the courts are struggling to balance two different fundamental constitutional rights, one of which is property rights, Fifth Amendment, with free speech, First Amendment. And so that's what all these cases deal with.
Roger, let's move on. And if you are a hunter, and you might have run into this, but this has to do with public lands and hunting.
Yeah, and this is a 10th Circuit Court of Appeals opinion, so it is binding in the state of Kansas. It's not just merely persuasive, but Kansas is part of the 10th Circuit. And what you had here was a situation involving hunters in the state of Wyoming, and you had an individual that had purchased a large ranch, and he was buying a whole bunch of acreage. I guess we shouldn't call it acreages, but we're talking in the thousands of acres of land around Elk Mountain, which is in south central, southeast kind of Wyoming. And it ended up he ended up owning this in a checkerboard fashion. So you've got the different color squares on a checkerboard. And what had happened was that you had Forest Service land that only touched on a corner, and he owns the land all around those two Forest Service tracts, and he owns the other corners. So the only way to access one of those Forest Service tracts was to cross at a corner. You couldn't go around. He owned all of that. You had to cross at the corner. And so he sued a group of hunters for trespass, saying, well, you can't access the Forest Service land without coming on my property. And what they had done was set an A-frame ladder with the feet of it on one of the Forest Service land corners, and it dropped on the other feet on the other Forest Service corner. And so they went up and over, and he sued for trespass. Kind of a nasty thing to do when you think of it. He's like, what's the damage here? He just didn't want him to have access. So this gets all the way into the federal court system, and they used an old late 18th century law that was dealing with the cattle barons. The reason it was passed was because of the cattle barons back then. And the fascinating history when you read the case. You learn a lot of things where the court gets into that discussion. Long story short, they said that's not a trespass. And hunters have rights. You have rights with respect to public land and access to public lands. And they said as long as you don't set foot on his property and you go up and over and the feet of the ladder on both sides are on public land, you're fine. So it's not a license in this situation to act inappropriately. It's not a green light to be reckless, but it does give us some clarity in the law that had been actually confusing for decades.
Definitely confusing as well. Just because, they would have put up a fence in that area, then that A-frame had to be, could have been a lot taller for them to be able to do, too.
Now, the other thing I would caution is when you try to find these corners like this, GPS can be off by feet, so you can get in trouble with respect to that. You could still be deemed to be a trespassing. So those signals, those GPS signals can be off, and corner markers can be buried, they can be missing, they can be hard to find. So it's a good win for private property rights in terms of hunting rights on public ground. But you're going to have to be careful to make sure you know absolutely where that corner point is at.
All right, another part of this we want to talk about, or another property rights issue, concerns environmentalists and defamation. In this case, came out of North Dakota.
Yeah, there have been some big developments in the Dakotas, both North Dakota and South Dakota, in recent weeks concerning pipelines. You've got the carbon sequestration pipeline. South Dakota has now gotten a bill through their legislature. The governor signed it that said you can't use eminent domain against these farmers and ranchers up here to cross their property to put this CO2 pipeline in. In North Dakota, a number of years ago, and I remember seeing the pictures of this on television and online, and it looked pretty egregious. This was back in 2016. You had people that were protesting an oil pipeline coming across North Dakota, and this was near Mandan, and they were claiming that you're disturbing tribal burial grounds and a whole bunch of other things. They don't want fossil fuel pipelines. They're opposed to fossil fuel. It's that crowd. And the energy company sued them and said, look, you've defamed us. You're causing problems with our lenders. We are not crossing tribal grounds. We've been careful to do that. And they won a $660 million judgment against these environmentalists by a jury in North Dakota. Now, it'll be appealed. We'll see what happens on appeal. But that sends a signal that there's a right way to exercise your First Amendment rights. But when you start damaging somebody else's property or their character, you've gone too far.
In other words, the difference between, say, free speech and breaking the law in this case, too.
Right? Yeah, we're back again in this case, just like the first case we talked about, of the courts balancing property rights with another fundamental constitutional right, and that's free speech. There's a proper way to exercise free speech without harming somebody else's rights here, somebody else's property rights.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us. We've got several issues of discussion that are taking place. And the next one, Roger, poses the question, what is a trade or business activity and why it matters?
It's actually a big deal, and this is one of perhaps more confusing issues that I run across with concerning farmers and ranchers and understanding why this is important to get this right. For example, if I'm a cash rent landlord, I am not engaged in a farming activity. IRS does not view that as a trade or business. You're in a rental activity. Well, that matters because of where we report the income from that and the deductions that we can claim. And we may or may not be eligible for certain other tax benefits in terms of write-offs, but we might. It just depends on what that particular provision is and the way that Congress has drafted the statute at issue. So one of the biggest concerns surrounding whether I'm engaged in a trade or business is, of course, the allowance of deductions. If you are engaged in a trade or business activity, your associated expenses are deductible, and your income now, through this year, and hopefully Congress will extend this, your income will qualify for the 20% qualified business income deduction unless you're a C corporation. Now, the downside, perhaps, is if you're engaged in a trade or business, you have to pay self-employment tax on your self-employment income if you're a sole proprietor, for instance. Now, how we determine whether you're in a trade or business is based on all the facts and circumstances of that particular situation. There was a case a long time ago decided by the Supreme Court, well, a long time, it was in the 80s, involving a gambler. And gamblers can't deduct their gambling losses unless they have winnings. But if you're a professional gambler, if you're in the trade or business of gambling, then you get to deduct all your expenses. And this went all the way to the U.S. Supreme Court, and the U.S. Supreme Court said the way we determine whether you are engaged in a trade or business is by looking at all the facts. And it doesn't matter if we're not just looking for a signature on a contract, for example. So this is going back to the old IRS CRP argument where they tried to say 25 years ago that, and to some extent they still say this in Pub 225, but it's incorrect. They tried to claim that, once you've signed a CRP contract, that means you are engaged in the trade or business activity of, I guess, not doing anything on the CRP ground. Well, as you recall, that has a long court history to it, and finally we got the courts to straighten IRS out on that and say that, no, your CRP rents are not subject to self-employment tax unless you're an active farmer. And that's the key. So a lot of areas, Greg, that we deal with landlord-tenant relationships, properly structuring leases, the way we do estate plans and succession plans to minimize self-employment tax, the way we structure entities, it all is turning on whether we are thinking we're going to trigger under the facts and circumstances, whether we're engaged in a trade or business or not. It really gets pretty complex, but at its core, those are the big issues. I can write off my expenses, and I'm going to have to pay self-employment tax. Where do I want to be in that whole realm, and how do we structure arrangements?
Let's move on to income tax basis. And, boy, that is definitely a key concept that can have a significant impact on your income.
Another big issue that's out there this year, we've got a lot of things going on, of course, in D.C. This is a big issue this week in terms of tariffs. This is Tariff Week. I've got a piece coming out on my Substack later today that kind of talks about everything that's going on in the courts. What are these judges doing? What's the authority of a lone district court judge to do national policy? Where are we headed with that? What's the scope of the executive's authority? Tariffs, how do they fit into all this in terms of revenue raising? And can we get a tax bill through because of that additional revenue and the expenses that DOGE is cutting out? That'll influence tax policy and farm policy. So that article is going to come out later this morning. I hope to final proof it this morning and get it posted to my Substack. But in this tax policy debate is, of course, the estate tax. And that's on a lot of people's minds. I mentioned this in Ottawa Wednesday evening, and you heard the reaction of some of the people talking about it. I could see their faces that, there's concern if that exemption drops from 14 million to 7 million, okay, we've got another problem. Well, we're really sitting in the best of both worlds right now. We have a relatively high, the highest ever, estate tax exemption, and you get a new basis at death for assets that are included in the estate at the time of death. It steps up to fair market value, or it could step down, but we think of it as a stepped-up basis. There has been talk in recent years, the prior administration had proposed bills to take away that step-up basis, modify it somehow. Maybe get your first million step-up and then no step-up past that, or tax appreciation on wealth, which would be detrimental to a lot of farming operations and small business operations, but farming operations in particular. So this basis issue is a really big deal. And the point on this, a very important point, is you need to keep good records of what your basis is. That's absolutely critical. Because if you can't establish what your basis is, the IRS has the ability to say it's zero, or put it at a level which will trigger a whole bunch of gain if you were to sell that asset. So the basis issue, Greg, in this whole tax policy discussion is a big issue, and hopefully they will retain that.
One thing wanted to quickly mention or get your thoughts on, we've talked about the Horse Protection Act final rule, and this, I don't say got buried in the news last week, but good news in that it's been delayed a year, or to February. I think it's February 1 next year of 2026. Yeah,
it has been. That happened a few weeks ago, and I thought that was going to happen when we got the new administration in place. They'd put that on hold, and now that not only on hold, they pushed it off, and I think probably what will happen is it'll get killed. I don't know for sure, but that's kind of what it looks like right now.
Okay. All right. Sounds good. And Roger, if people want to get to your article in your Substack, what's the best way they can do that?
Not the things we talked about this morning, but my reference to my Substack is McEowen, aglawandtax.substack.com. That's going to have the lengthy article talking about everything that's going on with the president, the executive, the judiciary, the issues that are headed to the Supreme Court, and how I think that will, and tariffs, and how I think this will affect tax policy and farm policy.
And it needs to be lengthy because there are a lot of spokes to this as well. So, all right. Roger, as always, appreciate it. Thanks.
Thank you, Greg.
That is Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law. He has been our guest on the Ag Issues program here on 580 WIBW.